Hello from Brussels. It's a real pleasure speaking to you also this year, as I did in the last editions of your conference. The European Union institutions are currently going through a transition from one political cycle to another. Naturally, this is also a moment of reflection about what has been achieved and what lies ahead of us. When I think about privacy and look back at the last 5 years, I see many encouraging developments and some areas requiring further work. I certainly see encouraging developments at the global level. When I travel abroad, I observe there is an increasing recognition of the importance of having modern rules of game on the responsible use of data. We may still have discussions with our international partners on the how, but I hear much less questions on the why compared to even a few years ago. That has allowed very significant progress in facilitating free and safe data flows. In particular, we have concluded several so-called adequacy arrangements with important partners, such as, for example, South Korea, and are currently negotiating new ones with Brazil and Kenya. We have also reinforced existing adequacy decisions to ensure their continuity and are working on expanding the one with Japan to cover new sectors such as research, following legislative changes in that country. EU-US data flows are, of course, another area of focus of our work. I recently went to Washington to discuss with my counterparts, Gina Raimondo and Merrick Garland, the implementation of the new data privacy framework in the context of its first review. As the first report we just published on this first health check concludes, all the elements of the framework are in place and functioning well. Our report also contains some recommendations on the way forward. You will get an opportunity to discuss all this in more detail in a session later today. But more should be done and can be done to enable data to flow safely. This is why we have modernized our system of model contractual clauses, which is the main tool European businesses use to transfer data. And we are working on further sets of clauses on the basis of the feedback we have received, in particular from companies. This is also why I launched in March of this year the Adequacy Network, bringing together like-minded countries to develop concrete, pragmatic solutions to maximize the benefits of safe data flows. And I'm very pleased about how that work is progressing. A lot is happening also at home. 2024 marks 6 years of the GDPR, and in July we published our second report on the application of this landmark regulation. It shows that the GDPR continues to deliver effectively for individuals and businesses. The report highlights the benefits of the GDPR's risk-based and technology-neutral approach that provides strong protection for individuals and proportionate obligations for data controllers and processors. Many businesses have developed an internal privacy culture. They increasingly see data protection as key to their competitive strategy. But, as identified in the report, there are also challenges that we need to address. You will hear shortly more on our report from a Commission expert in this field, Olivier Micol, but let me mention 3 areas requiring improvements. First, there is a need to step up efforts to support compliance by SMEs, including through the development of tailor-made guidance and tools. This should also reflect the risk-based approach, as many SMEs do not have data processing as their core business. Second, consistent interpretation and enforcement of the GDPR must be ensured throughout the European Union. Too often, national data protection authorities adopt diverging interpretations on important data protection concepts. This creates legal uncertainty for individuals and businesses, increasing costs and obstacles to the free flow of data in the Union. This issue is also identified in the recently published Draghi report as one which may discourage innovation and investment in Europe. Addressing this question requires a collective effort from the EDPB, national data protection authorities, but also the European Union legislator. Last year, I proposed the GDPR procedural regulation to foster coherent enforcement. These procedural rules will not amend the GDPR, but complement it so that data protection authorities can work earlier on and better together on cross-border cases. I hope the new regulation can be soon adopted under the new legislature, on the basis of the work already done in Council and Parliament over the last year. Once this regulation will be in force, and in light of the experience gained from its application on the ground, it will need to be seen whether further measures are necessary to ensure a consistent enforcement of the GDPR. This may include, among others, considering possible adaptations to the governance model. I'm hearing, for example, ideas about strengthening the role of the EDPB as a pan-European regulator for certain cross-border cases, drawing inspiration from other regulatory systems, such as competition law. And thirdly, data protection authorities need to be equipped to do their job. While most authorities have been given more resources in recent years, many still lack specialized technical and legal knowledge and have difficulties recruiting and retaining staff. This is more important now than ever before. In a union like ours, DPAs need to talk to each other, and they need to communicate with regulators in different sectors, as many of the EU's new digital regulations involve competition, consumer, media, and cybersecurity questions too. As you can see, when this conference will meet again next year, there will still be much to discuss and debate. But what is clear is that to develop useful solutions, we need your feedback and suggestions. My colleagues and I look forward to hearing them today. Once again, it has been a pleasure to address you this year and over the last few years. Thank you, Bitkom.